Today, our guest is Shelli Strahle. She is the founder and CEO of Strahle Legacy Planning Law Offices. She's an estate planning attorney licensed to practice law in California. Strahle Legacy Planning focuses on wills, trust administration, and probate. Shelli attended UC Davis for her undergraduate degrees of French and linguistics, where she graduated top of her class, then went on to get her JD from the University of Pacific McGeorge School of Law, where she made the Dean's Honor List. Shelli also attended a law abroad program at the Sorbonne in Paris. Shelli organized her practice in such a way that she's able to spend more one-on-one time with her clients in order to ensure that they get the outcomes they desire. Creating a living trust can save your loved ones from the headache, delay, and expense of probate. Welcome, Shelli.
Thank you for having me.
I'm honestly so excited to talk about estate planning with you today. I cannot tell you. As we kind of touched on earlier, I have had a lot of opportunities to curse the lack of estate planning within my family. Unfortunately, over the last few years, we've had several losses and we've had challenges with each of those. So I think this is a topic that oftentimes people don't realize that they need until it's too late, or until they're confronted with it and it's right in front of them. So I'm super excited to have you here today. And this happens to be one of those topics that doesn't apply just to business people, but it applies to everyone, every adult person. It makes a big difference. So I am going to ask you a quick question. How did you end up getting into law? French and linguistics is awesome, but it seems like a sharp right turn to get into the practice of law.
Yeah, so actually it was not. When I was 12 years old, I announced to my parents that I wanted to be a lawyer, and they, said, okay, that's a nice dream. And they didn't realize how serious I was. And then when I was in high school, I interned at the public defender's office, and I liked it, but I knew I didn't want to go into criminal law. And then when I got into college, they didn't have a pre-law major. So I was lost. I didn't know what to do. So I took all sorts of different subjects, and I fell in love with French, and then subsequently fell in love with linguistics, which is the study of language in general, and had a great time, learned a lot, and then applied for law school. And if anything, I think it differentiated me from other people that did more typical majors toward law.
Absolutely. And I think it's wonderful. And I'm completely jealous of you for getting to spend time in Paris and having that type of a law abroad program has got to make you certainly more well-rounded, I would think. Just an understanding. Yeah, that's great. That's really good. So let's talk about the basics. Why do I need a living trust, and how does that differ from having a will?
Yeah, so when someone dies with nothing in place or a will, if they have over $150,000 in assets, and that's including the fair market value of a house, the assets have to pass through probate to go to the loved ones. So a lot of people don't even understand what probate is. So it's a court process to transfer assets, and it's long, it's expensive. It doesn't matter which attorney you hire. It's set by state law how much the attorney gets paid. There's an executor that can also take fees. They get the same percentage as the attorney, and then there are filing fees. During COVID, the probate courts actually shut down. So there was no way to transfer assets. And it's always it can take 6 months, even up to a year or longer. And versus having a trust is a document that you set up a trustee to take over when you pass away for the beneficiaries. And so if you have minor children, the beneficiaries can be minors, but you have the adult trustee, and you're able to avoid the entire probate process by having the living trust. And it's revocable, so you can change it anytime you want.
I think that's a key. So I'm going to ask you for instance, let's say that we have to go through the probate process because I own my home and it has a value in California. An empty lot has a value of over a couple $100,000. So in that case, if I were to die, does somebody still have to keep paying my house payments during all this time it's in probate?
Yeah, well, I mean, that's the tough thing, is who has the authority to do it during that time. And when you don't have a trust set up, it gets confusing. Do you just try to keep paying stuff? Do you let people know and then they say you don't have authority? You have to wait even to get the initial court hearing date to be determined that you're the executor or the personal representative when there's no will. Can take months. So it can make it challenging if there isn't a trust in place.
Right. So theoretically, it's possible that you might have to come out of pocket because you don't have authority to use the trust, you don't have the deceased's funds to pay their bills, that you would have to continue to pay those bills during the time it's in probate. So to me, that's a huge wake-up call. If you're thinking about trying to settle somebody's estate, even if it's not a huge one, but if you're already supporting your own family and then you have to, to deal with that as well, that would be quite a financial consideration, I would think.
Yeah, well, and then property taxes as well. So if it's, I don't know if you followed Prop 19, but Prop 19 made it where you can only transfer the principal residence to a child who makes it a principal residence to not be reassessed. And even then, if it's a house from the 70s, it might be reassessed a little bit. But when you're transferring assets that aren't your principal residence, so if it's just an income property to children, or if you're giving anything to non-children, then that entire time that the property is stuck in probate, even if you're selling it, you're going to owe back property taxes for the new reassessed value. And so that can be another financial hit if it's stuck in probate.
Yeah, absolutely nuts. So you've convinced me we need a living trust.
Yeah. Well, and so probate is a court process. You have to file documents. There's time for creditors. There's an inventory and appraisal. It's a whole process before you can even reach the distribution phase. Whereas when you have a trust, you're filing an affidavit of death of trustee, and then from there you can either sell while it's in the administration, or you can distribute to the beneficiaries. And it's literally a difference of filing a few documents with the county recorder versus a huge court process.
Yeah, that's crazy talk in my world. And I've known from the as I said, we've had some deaths in the family over the last few years. It starts to pile up. It can become a full-time job for a few months trying to contact people, get responses back, file the appropriate things that you need to do, all the things that come up with having a loved one die and having to settle their estate. So having the court having the trust documents in place and having that part streamlined would make a huge difference, especially dealing with assets, creditors, all the things that you need to. So like I said, you convinced me, no question. And now, what about if you don't have like really significant assets? Maybe you're a renter, you've got a car, you've got a bank account, you've got, your furnishings, household furnishings, but maybe you don't have any real property or something like that. Then how does that work?
So the only time I don't recommend having a trust is if you can set up everything with pay on death beneficiaries. So if you have life insurance that you can list beneficiaries and you keep that up to date. If your bank accounts aren't over a significant amount of money and you either have a joint tenant or you have pay on death beneficiaries, you have to be careful with joint tenancy though, because the person you add as a joint tenant has access to the money. So right. It might not be your intention that they are able to take it during your life. And so if there are truly a small amount of assets and you can structure everything to pass through pay on death beneficiaries, then I think it's okay to just write up a little will for your personal effects and your car. But otherwise, so even if you don't, let's just say you have one house and nothing else, then you definitely want to have a trust, because if you go on Medi-Cal, and we mentioned that a little bit earlier, if you go on Medi-Cal and you are over age 55, even though it's free to you during life and they won't come after a spouse, when you're gone, they'll come back for reimbursement, but only if your estate ends up in probate. So you really want to make sure that you have a living trust set up, even if you don't have a lot of assets, to protect the family home, because even if it's just for end of life expenses, that can add up, and they'll come back and they'll force a sale of the house. And it's really sad. And they're barred from reimbursement if you have a living trust in place.
Yeah. So let's clarify that. Medicare, which is the health insurance program that seniors go on after age 65, right? That is not what we're talking about. We're talking about end of life care when you get hospice care, you get home health nursing, those sorts of things. Those tend to come out of Medi-Cal. And it might not really like draw you a picture of what that's going to,
or skilled nursing. If you need skilled nursing, usually Medicare doesn't cover it. Or, you know, there are also just people where they go on the income-based Medi-Cal as well. So just all of those, if you're over age 55, the state can come back for reimbursement if your estate ends up in probate in any way. And that brings up another point that a lot of people think, oh, I have a trust, I created it 20 years ago, it's fine. Is your trust properly funded? So if you have assets, they have to be titled in the trust. And so if they're not titled in the trust, it might still end up in probate if you haven't reviewed your trust in a long time to make sure that all of the assets are properly funded. And then if they aren't properly funded, have you gone to an attorney to make sure that you have all the documents set up for what's called a Hagstad petition? And a Hagstad petition is where an attorney would go in and say, okay, yes, the house wasn't in trust, or this investment account was not in trust, but based on the trust schedule and this updated pour over will and this general assignment, we should avoid probate anyway. And so you need to have the documents in your trust package to make sure that an attorney later can argue that you should avoid probate anyway. And that way if you go on Medi-Cal, it still is shielded from reimbursement.
Yes. And again, the Medi-Cal reimbursement could force a sale of your home. You might think that you're passing your home along to your children or your spouse, not your spouse, but your significant other, somebody like that, and come to find at the end that the bills are so significant that's not going to happen. The house has got to be sold, correct?
Yeah. And then another reason that someone that even if they don't have what they would consider a lot of assets, or maybe they just have one child, so they think, oh, nobody's going to fight over this. I don't need to create an estate plan. I just have one child. Well, that one child is still going to have to go through probate and still going to have to hire an attorney and still is going to have to deal with the same Medi-Cal issues. And so you want to have it's even more of an incentive to set up an estate plan with a trust, because with one child, it is the most simple process imaginable. They don't have to give notifications to beneficiary. I mean, they are the trustee, they are the beneficiary. It can be done in a month or two when you have one child that is the trustee, just handling it to give it outright to themselves. So it just doesn't make sense in that situation, to have anything but a trust if you have over 150,000 in assets. But people, they think that a lot of times they think setting up an estate plan is to prevent fighting. Well, it's also to prevent ease and reduce cost.
Yeah. So let's touch on a couple of unusual, well, they're not unusual in this day and age, but unusual situations. I am a step parent and I have a significant other that I'm not married to. And I have a biological child. So you mentioned, fighting over assets. So obviously that's a concern, but and I'm not asking for you to create my estate plan, But how do you deal with these unusual situations so that you make sure that things happen the way that you intended? There are a lot of moving parts in that kind of scenario, but I don't think it's unusual in this day and age.
Yeah. So I have quite a few clients that they do set up a trust for their child. You know, if they get a partner later in life that they aren't getting married to, usually each partner would have their own estate plan for their own children, because they usually both have children, and that's just an agreement that they come to. There are certain trusts that become irrevocable on the first death of a spouse, but that does have certain negative income tax consequences. So it's a case-by-case basis whether that's right or not. And another possibility is when you are married and then one spouse passes away, to put on a child as a co-trustee so that they can kind of keep an eye on whether someone's going to come in and try to take advantage and be aware of what's going on. And then I always recommend, if you're going to get remarried again, to get a prenup. And so a prenuptial agreement, a lot of people, they think, I love my spouse, I don't need a prenup. Well, the prenup isn't about that. It's about protecting your own children, because when you get the prenup, it ensures that your children will always inherit.
Yeah, there's excellent. And one of the other things that I always heard about a prenup is it's the right time to figure out what's fair and what's just, because you have that glow of love and affection, whereas, you know, later on, if you have to execute the prenup, the provisions of it might not end up being, you might have a more adversarial position. So,
right. Well, and then I think when a lot of people think of prenuptial agreements, they think of it in terms of divorce. They don't think of it in terms of death, but it's really protecting your children upon death.
I love that. I absolutely love that. And because it can absolutely be a challenge to try and sort through what all the issues might be. And being able to kind of lay that out ahead of time makes perfect sense. So I think we covered, there are just a lot of different scenarios that creating a trust can help with. And you pointed out you might actually need to make two trusts, or, you know, create a second document if your situation's quite complex, for each partner or something like that.
Mm-hmm. Yeah. Well, and you should, if you're not married, you should each have your own separate documents.
Okay, perfect. And so now I want to save a little bit of money. So I'm looking at all the online places that I can create my own trust document. And why is that not a good idea, especially if I have a simple trust, or what I think is a simple trust?
Yeah. So what I have found in this business is that there's always something unusual or unique about every situation, and nothing is ever really simple. But a lot of people call in and they say, oh, I just have a simple estate plan. Well, there's always something unique. And those online systems, there's no professional looking over what you're doing. You are basically drafting your own estate plan. So if you make a mistake, I've actually had clients that came to me for a trust because they ended up inheriting through a huge trust litigation because she input the names incorrectly in the software and no one is looking that over. You're just creating your own documents. Are they specific for California? What I've seen is a lot of those documents set up nationally. They don't have general assignments, which I would use as part of a Hagstad petition. Is your trust properly funded? Did you go through and retitle everything? No one's overseeing any of that. And then my process, I have an initial consultation. If we decide to move forward, I have a design meeting so the initial consultation, I'm just reviewing the assets. The design meeting, I'm just reviewing the decisions, making sure that we understand each other, making sure that you understand all the different terms. So that's the other thing when you're doing your own estate plan online. Do you really understand these different roles and who you're choosing for these different roles? And then I have a draft meeting to make sure that there are no errors, such as putting the wrong beneficiaries or spelling errors, anything like that. Did we cover everything? Is there something you thought of after? Then we have the signing, and then we have a review meeting to make sure that you understand everything that you signed, and you can invite your successor trustee to attend that meeting to get an introduction to everything that you want to happen if you would like that. So it's a whole process that if you're doing a little online form by yourself, you're not going to have, and making sure the trust is properly funded.
Yeah, I was going to bring that up because I think that's the biggest challenge of all, is making sure the trust is properly funded. People set up the trust documents, or so I've heard, set up trust documents all the time, and then they don't fund them properly. They might even name their bank accounts or what their assets are. And then, as you said, there's a petition that you can file after your passing to say, well, these things should have been in the trust, but that's another delay, and it's another expense, and it's another thing.
If you use an online service, they might not provide all of the documents you needed for that petition. So just having the trust is usually not enough for that petition to be granted.
Okay, so I think you've driven the point home. We need a trust. I think one thing that holds people back from creating a trust is the expense. I mean, and the concern that, okay, I've created my trust today and I spent all the money, to make it, set it up, and did all the things. And now things change, or maybe I think they haven't changed, but in fact, when I sit down and review everything, oh, wait a minute, I changed that bank account, or I have a new grandchild, or, I got into a fight with my sister, or whatever it might be. Things change over time. So
minor children become adults, and then all of the people that you chose don't make sense anymore.
Yeah. So exactly. So how do we budget for this, or how do we understand what doing this the right way is going to entail?
So I would definitely recommend checking in with an estate planner every 5 to 10 years. 5 years is better, but if it has to be 10 years, that way, if you're married, especially looking at, have the laws for income taxes and estate taxes, have any of that changed? I would just always be looking at who you chose for certain roles. Do they still have mental capacity? Do you still like them? Does it make sense now that children are older? So looking at all of those things, or maybe the people that you chose, have they had a falling out of any kind? So I've seen, co-trustee children listed, but the children no longer get along. So that doesn't make sense either. So you always want to check in. So I offer a complimentary client maintenance program where my clients can check in with me as often as once a year. So the check-in is free of charge. If someone actually wants to make changes, then it would be at my hourly rate to make the changes. And so you were asking about budgeting. So if it's a small change, if you're just changing the trustee, you would make an amendment to the trust, update the pour-over will, which funnels assets to your trust, and probably get a new certificate of trust. And so that would just be billed at an hourly rate. But if someone comes to me and they haven't made changes for 15 or 20 years, it's usually a restatement. And a restatement basically makes a new trust document. The content of your trust is new, but anything that's properly titled, you don't have to go out and retitle the house and retitle the bank accounts so that everything stays properly titled. And a lot of people come to me for a restatement package and they find out there's actually nothing in the trust and they thought there was.
Yikes. So that's perfect. Oh, and maybe not one last thing, but one more thing is, you talked about Prop 19, and I read the content of that, and I understood it, but the advertising I felt was very deceptive when people were being asked to vote on that. So Can you kind of discuss it a little, because it's law now. So can you kind of discuss what it is that the change? I know you mentioned it before, but I just kind of want to underscore it so people understand what that is all about.
So I think it's better to start with what Prop 58 was. So Prop 58, which has now been superseded by Prop 19, under Prop 58, you could transfer an unlimited amount of principal residence property to your children without being reassessed, and $1 million of adjusted base year value, not even fair market value. So whatever it was listed on your property tax bill, you had $1 million that you could transfer of other property. So income property, industrial property, farm property, anything, you could transfer an extra $1 million plus the principal residence. So Prop 19, and yes, it was very deceptive. The face of the proposition, it talked about all the great things about Prop 19, about moving your tax basis when you're over a certain age or a fire victim or disabled. But all it said was makes changes to family transfers. It didn't say what the changes were. And then there was another proposition on the ballot that was only attacking industrial and commercial, and it was a big dispute, and it didn't pass, which makes me really think that no one understood what they were voting for on this one, because this Prop 19 made that whole argument moot, because it made it so now anything that isn't the principal residence of the parent is going to be reassessed. So any vacation property, income property, it doesn't matter what it is, if it's not the principal residence, and then they've also now included the family farm, but we're gonna have to figure out what family farm means. If it's not the principal residence of the deceased parent, and now the difference with Prop 19 too is the child or one of the children must make it the principal residence within a year of death and actively file the homeowner's exemption. Whereas under Prop 58, you could wait 5 years and then go file some documents, and they'd even make it retroactive up to a certain point. So now you have that 1 year requirement that you must file it. Also, it had the parent, in determining whether it was the principal residence, they have to be eligible for the homeowner's exemption, which means if mom moves into a nursing home and you rent out mom's house, is that no longer eligible for the homeowner's exemption? So it might make it where it won't even pass under Prop 19. So we have a lot of stuff we have to work out. There's still passing legislation to sort of work out the kinks, and I don't know what they're going to do on that one, but it has to be eligible for the homeowner's exemption. The child must actively file the homeowner's exemption and all of the assessor paperwork within a year. And here's the real big one. So under Prop 58, once it was determined that it went parent to child could do anything they wanted with the property. Now, child must maintain it as their principal residence. And the moment that they decide to rent it out or do anything where it's not the principal residence, it's going to be reassessed. So it pretty much made it where you can't have rental income from properties that you inherit, because you'll be reassessed.
Yeah. Yeah, there's a lot. Well, in my personal opinion, the family home tends to be the one biggest wealth creator that people get. And there are so many individual children, millennials, whatever you want to call them, that simply can't afford to purchase in California. However, it doesn't mean that if they're actively working that they can pull up stakes and move to mom's house immediately, even though that might be their goal for retirement, or it might be something that they choose to do later on. So this has created, I think, in my opinion, a great challenge to being able to build wealth for middle-class families. And you know, I understand the sentiment. I understand some other things that go along with it, but I do feel like it's a huge challenge, especially in the California real estate environment. So I think it's important, though, as an estate planning tool, to understand what the ramifications are, so that no one's blindsided when they're creating their estate plan. If multiple individuals inherit your primary property and or they don't live in it, the property will be reassessed. Is that correct?
Yeah, if none of them live in it. Mm-hmm. Yeah. And then the other thing too is under Prop 19, let's say you purchased in the 70s or even the 60s, there's a formula that they look at where they plug it into a formula. And so you still might be reassessed to some extent. So under Prop 58 before, you could pass your Prop 13 unlimited. Now they're going to plug it into this formula. So there still might be some reassessment, even if you follow all the steps and make it your principal residence later. So
yeah, just very, very challenging. Okay, so we talked a lot, and I know we've only touched on the surface. There are a lot of questions I still have for you, which if you guys would like more information from Shelli, definitely let me know in the comments. But there are business planning ramifications that you need to consider also. So and that needs to be part of your estate plan. So that's something else to consider. But what I like to do now is ask if somebody wants more information or they want to take advantage of that free consultation, how do they get a hold of you? And then can you put that information in the chat so people can contact you?
Yeah, so first off, I'll start with my website. So my website is www.santacruzestateplanning.com. And it says Santa Cruz, but I do consultations by Zoom. So I'm not limited by distance. I am limited to only practicing in California. So, and then the phone number is 831-621-2165. And my email address is Shelli, Shelli, @santacruzestateplanning.com.
Perfect. That's wonderful. This has been hugely, hugely helpful. I think a lot of people don't realize the challenges that they're going to face when someone passes on. And I know for myself, I don't want to have someone that I care about grieving and trying to unravel all of this stuff and paying money that they, may not have to spend to try and put my estate planning into place. So I really, really appreciate this, Shelli. And like I said, I think that we're going to revisit this with some other questions and topics. So definitely let me know if that's of interest to you. And I will, hopefully we'll be talking very soon.
Thank you for having me.